So, officially, everyone, welcome to this week's session of the Belgrade Legal Theory Group. Today we have the honor of hosting Professor Marcin Matczak from the University of Warsaw, Faculty of Law and Administration, who will speak to us about the state of emergency in Poland, a constitutional Schrodinger's cat. I am extending a warm welcome to each and every one of you from a rather rainy Strasbourg. And without any further ado, I would like to give the floor to Professor Matczak. Professor Matczak, the floor is yours.
Thank you very much for this opportunity. Thank you for inviting me to this webinar. I would like to start with apologies. I'm in a car, as you can see, because I'm outside Warsaw, and that's the only place, a calm place, I can talk to you. So that's the reason why I'm in a car. It's not that I'm running away from Warsaw because the pandemic is so extreme that I have to, but because that's my situation. I'm outside Warsaw, and that's my office. Let me tell you something about myself. I'm a professor of legal philosophy at the University of Warsaw. But at the same time, I'm a practitioner, and I work as a lawyer, as a partner in one of the biggest Polish law firms, which gives me, I think, a unique opportunity to somehow merge my experience as a legal philosopher and someone interested in theoretical aspects of law and my practical experience. I have been working as a practitioner for almost 20 years now. So I think it's easier for me to understand how the law operates in the social reality and in real life. And I will be trying during this meeting to show you how the law and the regulations concerning the state of emergency in Poland may impact real lives of real people. And because I think it's important, we should not forget that law is not an abstract set of rules, but it is a tool of solving social problems. And if it is a bad tool, these problems remain unsolved, and we should be aware of that. I have been also involved in public discussions in Poland concerning the state of emergency. As you probably know, the situation of Poland during last 5 years, as far as the rule of law is concerned, is not optimal. Since 2015, when the Law and Justice Party won the election, we are experiencing a backsliding into authoritarianism. And I believe that the state of emergency and the pandemic, COVID-19 pandemic, showed how important and how harmful this backsliding can be to people's rights. And I will dedicate some time in my speech, in my introductory speech, to this aspect as well. So I have been involved in the public discussions concerning this backsliding process. You must know that I may have some bias against the governing party in Poland, because I'm perceived in Poland as a harsh critic of their actions concerning the infringing of the constitution and infringing the independence of the courts. So please bear that in mind, and if I'm not fully objective, so please tell me. As I said, I may have some bias in this respect. So as I said, I have published in the Polish newspapers, and I have been commenting the news concerning the pandemic in the Polish TV as well, and I've been preparing as well some legal opinions for the Polish Parliament concerning the laws that were enacted during last 4 or 3 months. So I think, bearing that in mind, that I have quite good knowledge of what was going on in Poland, and if you have any questions concerning both the theoretical aspects legal aspects and social aspects of the crisis of the COVID-19 pandemic and the state of emergency, I will be happy to answer your questions. So let me start with the title. I was asked to propose a title, so I referred to Schrodinger's cat. As you know, this is a very special animal. We know from quantum physics that the problem with the Schrodinger's cat is that we cannot be sure whether it is dead or alive, whether it exists or not. So I have chosen this title because what we face in Poland now is a Schrodinger's state of emergency, I would say. We are not sure whether we have it or not, whether it exists or not. Because on the one hand, I mean, if you look outside the window, there is a state of emergency. For many, many weeks, we had a lockdown in Poland. The public institutions were closed. Schools are closed still. We were not able to carry out the presidential election. We were not able to travel freely, and so on and so on. On the other hand, our government has been trying to convince the citizens of Poland that everything is okay, and the situation is so good that we can hold the presidential election, and that we have a full control over what's going on in Poland. So this is going to be one of the main topics, because I believe that if you have a state of emergency and you fail to announce it, so it's quite a comfortable situation for the government, because you can limit the rights and liberties of the people without being constrained with the regulations concerning the state of emergency. So this is the explanation for the title. I personally believe that we have a state of emergency, and all the constitutional rules concerning the state of emergency should have been introduced many, many weeks ago. Our government believes that we don't have a state of emergency, and therefore we don't need to use the constitutional state of emergency, but some statutory regulations that give a lot of freedom to the government as far as the limiting of the people's rights is concerned. So that's the Schrodinger's cat, and that's the Schrodinger's state of emergency. So let me start from the beginning of the pandemic, because Poland. Poland got the information about the pandemic in February, January, February, and when it reached Poland, it turned out that the Polish government took some stupid decisions just before. So just to give you an example, despite the information that pandemic is coming, the special governmental agency put to sale the more than 60,000 masks, and they sold it, even if then after several weeks there were shortages of masks in Poland. The first reaction was that the COVID-19 is a regular flu. So I think you can compare the Polish government's reactions to the COVID-19 to President Trump's reactions. Yeah, underestimation and I mean some information that everything is under control, there is no threat. Unfortunately, it was not the case, as we all know. And I mean, just after the period of underestimating the threat, the Polish government started acting very forcefully and quickly. And I think we were all very fortunate that these decisions were taken. So 4 days after the patient zero was diagnosed, there was a first decision about the state of epidemic threat, which is a statutory tool in the Polish law announced by the Prime Minister together with the Minister of Health. First decisions concerning lockdown were quickly followed. and around the 20th of March, the next stage of the state of the pandemic was announced. So first the state of the pandemic threat, then the state of pandemic. These states are a kind of emergency states. However, they, as I told you at the beginning, they are regulated at the level of the statute, of the primary legislation. And the decision taken on the basis of the primary legislation are generally taken at the level of secondary legislation by the minister or by the prime minister, which makes them very easy to take because, of course, they don't need to go through the parliament. Yeah, the minister or the prime minister simply decides on the basis of the primary legislation. And here I have to make a comment about the rule of law situation in Poland. Unfortunately, these decisions by the Minister of Health or the Prime Minister cannot be scrutinized by the Polish Constitutional Court. I mean, not formally. Formally, they can, but as you probably know, in 2015, the Polish governing party took control over 2015-2016. They took control over the Polish Constitutional Court, first by a process of court packing, then by paralyzing the court, and then by changing the head of the court. So at the moment, the head of the Polish Constitutional Court is a close friend of our de facto leader, Mr. Kaczyński, and they meet from time to time. And Ms. Przyłębska, who is the head of the Polish Constitutional Court, as Kaczyński proudly says, is preparing dinners for our de facto leaders. So this connection is so close that they are friends. As you know, for the constitutional review, when the politicians and the judges are friends, that's bad news, because this link is simply too close. And the number of the cases, after all these changes to the Polish Constitutional Court, the number of the cases at the moment is at the level of 20% of as it was before 2015. So it's a clear sign of distrust to the Constitutional Court. And during last 4 years, because the 1 year that was the old Constitutional Court, during the last 4 years, I cannot show you any decision that would be contrary to the to the will of the intentions of Kaczyński and the Law and Justice. So if you have a constitutional court that is a fake court, it doesn't work. So, and you have the Prime Minister and the Minister of Health that are issuing some secondary legislation. So even if formally you can file a motion to the Constitutional Court to check if they are compliant with the Constitution, it doesn't make any sense, because the outcome is clear. So no attempt to challenge the regulation was made. And these decisions undertaken by the Polish government were, I mean, very quick, but also they were changed very often. So every 5 days we had a change, a very quick publication in the official journal. No vacatio legis, so a very quick changes, very difficult, a lot of difficulties to adapt to them, and as I said, no control by the Constitutional Court. And some of these decisions were very harsh, I would say. As I said, lockdown, the ban on travel, the decision to close the schools, the decision to close the courts as well. So they were not operating for several weeks. And as I said, all that based on the primary legislation, all that covered by the secondary legislation, and no control by the Constitutional Court. And I think it's interesting to ask a question why the Polish government took this path. And the reason is politics, because as it turned out, the politicians and the Law and Justice Party were very keen to organize and to hold the presidential elections that were originally planned for the 10th of May. And the problem is that according to the Polish Constitution and the case law of the Constitutional Court, you cannot hold elections in the middle of the state of emergency. That was the reason why the state of emergency was not formally announced, because the Polish constitution says that if the state of emergency is formally announced, you have to postpone the elections. You extend the term of office of president in this case, and you wait until the state of emergency ends. So in the Polish constitution, you have three types of state of emergency. There is a martial law, clearly not applicable here. A state of emergency which is normally announced if the constitutional order is in danger. Again, not the case. And the third one, the third type of the constitutional state of emergency is a state of natural catastrophe. And this is the one that should have been imposed or announced, because according to the Polish legislation, one of the premises of announcing the state of emergency, the state of the natural catastrophe, is that you have a pandemic, you have a contagious disease, it's spread around the country. So all the premises have been, in my opinion, not only in my opinion, the opinion of the Polish ombudsman, all the premises have been fulfilled. Nevertheless, the Polish government refused to announce formally the constitutional state of the natural catastrophe. The only reason being that that announcing it would make the election impossible. And it was very important for them, I think, it was very important for them to have the election, because the Polish governing party and the president, who is supported by this party, were afraid that the longer we are in the pandemic situation, the more difficult it will be to win the election. So it makes sense to have the election in May more than to have them in September, for example, when the social mood and the people's perception of the situation will be much worse. So here we have the Schrodinger's state of emergency. On the one hand, we have a lockdown, we have the public institutions not working, we have, for example, the complete ban on public assemblies. And on the other hand, there is no announcement of the formal state of emergency, because the government wants to have elections in the middle of pandemic. And they tried to do so. They changed the election laws, which again is against the Polish constitution. In Poland, you cannot make changes later than 6 months before the elections. So the last change concerning the Polish elections, presidential election, came into force 3 days before the election. And that was the idea of universal postal ballot. So you can imagine to have 30 million people voting by post, and absolutely impossible, situation and task. So all in all, the government decided finally that it is impossible to hold the election. But I'm talking about the election because I believe that was the crucial factor, the crucial reason why we had such a strange situation. And just to give you an example why the situation was strange, the difference between the statutory states of emergency imposed by the government by means of the secondary legislation and the constitutional state of the natural catastrophe is that the former is not limited in time. And the constitutional state of the natural catastrophe, of course, is limited in time. So the Constitution says that it can be announced for 30 days and then extended only with the consent of the Parliament. The regulations concerning, for example, compensations to the people and the firms are different if you compare the statutory state of emergency and the constitutional state of emergency. Of course, normally, the situation we are talking about would be challenged in the Polish Constitutional Court, and with a normal court operating, I think there would be no doubts that that's an unconstitutional situation. And here you can see how important it is to have an independent constitutional court and how detrimental to the Polish situation and the Polish citizens is the fact that you have a fake constitutional court, and you have government that is using the secondary legislation to limit the rights of the people. So to sum up, at the moment in Poland, we are waiting for the next election. The presidential election will be on the 28th of June. Again, that makes it impossible to introduce politically impossible to introduce the constitutional state of emergency, because that would make this election impossible. Of course, there are constitutional questions whether the election will be constitutional, because, for example, the Polish citizens living abroad probably will be deprived of the rights to vote because of pandemic. There is a big number of the Polish citizens in the UK when you still have some kind of limitations, so it's unclear how they are going to vote. So we are still having, I mean, a real state of emergency. Still, the constitutional state of emergency has not been announced, so it is not clear. It is absolutely depending on the discretionary powers of the Polish government, what kind of limitations and how and for how long they will be introduced. And one more thing, which I believe it's quite important here, I believe that there is no thinking in the whole situation, no thinking in terms of proportionality of the tools that have been used by the Polish government. So, as I said, the first response by the Polish government was very forceful, very harsh. Very quickly, they introduced in March limitations on the business activity. At the same time, no thinking about how to unfreeze this business activity was in place. And some decisions were difficult to understand. So, for example, just to give you an example, at one moment, the Polish Prime Minister decided to close the public forests, which normally seem to be quite safe places to be during the pandemic, because you cannot expect to have many people there. So we had the churches open and the forests closed, yeah, which is quite a strange situation, I would say. Then after a week, the forests were open, yeah, again, and again, no justification for that. Why we should open the forest and not, for example, to open the hairdressers, let's say, yeah. So no evidence-based legislation here, no analysis, no regulatory impact assessment, no assessment of the proportionality. My impression was that these were very arbitrary decisions depending on what is the expectation of the electorate before the presidential election. So my impression is that instead of saving the lives of the people and the health of the people, the Polish government was too much focused on the political aspects of the whole situation. And that's another constitutional problem, because the constitutional state of the natural catastrophe was meant to be used in the situation like that, exactly for that reason, to allow the government to focus on the people's life and health and not on organizing the election. And the parliamentary time within April, I think, was dedicated in 90% to changing the election laws and not to preparing good laws for the pandemic, which I think is one of the reasons why the laws limiting the business activity and people's freedoms were simply of poor quality. Because if you don't have parliamentary time to sit on the laws, to analyze their consequences, to analyze the data, because you are involved in the political discussions concerning the election laws, there are, you cannot have as an outcome a good quality law. So I think that's an important thing as well. So to sum up, I believe that the Polish situation is a situation from many countries can learn. So first of all, I believe that we were not well prepared for the pandemic. I mean, in the political sense, in the sense of resources and so on and so on. Fortunately enough, the decisions of the Polish government were quite quick and they so I think it somehow limited, for sure it limited the spread of the disease. But the crucial problem, legal and constitutional problem, was that the Polish government should have announced the constitutional state of natural catastrophe, to postpone the elections, to extend the term of office of the president, and to focus on helping people in such a difficult situation. They did otherwise. They focused on the elections, and in my opinion, it influenced in a detrimental way the quality of the laws concerning the state of emergency, the proportionality of the laws, and many limitations of the Polish citizens' freedoms and rights were unnecessary. At the same time, we were unable to challenge them in front of the Polish Constitutional Court because, as I told you, it is not working. So I think that would be my introduction. I hope that I touched upon some interesting issues for you, and I'm open to your questions if you have any.
Thank you, Professor Matczak, for your presentation. I would like to ask anyone who has a question to request to ask that question by raising your hand. You can do so by hovering your name and clicking on the little hand icon. We have a question from Teodora. Teodora, you have the floor. Just a second. You can speak now.
Hello, Professor Matczak. I'm very happy actually to have a chance to.
I'm sorry, I have troubles hearing you.
Hearing me.
Oh yeah, it's better now.
Okay, I'll try. I'm as I said, I'm happy that I have a chance to listen to your lecture today.
Sorry, I can't hear you again. Hello?
Maybe this will help. Can you hear me better?
Yeah, it's better now. Yeah, thank you.
Okay, I just, as I said, I'm working on judicial reforms in Poland as my research topic, so I have a lot of questions. But in regard to the pandemic, some specific questions. You mentioned that the statutory regulation was applied to this emergency situation. My question is, were those laws that were applied introduced under this government or before this government? Because I'm just curious, if there is no time limitation, how come that never reached the court before in regard to the proportionality of the measures, in regard to constitutionality of such law, if there is no time limit in the law itself to the human rights limitations? That's one question. And the second question is, do you really think, because you mentioned that the government was scared that it's worse to have elections in September, do you really think that there is actual chance that something will change in those elections? And the third question is, as I'm also carefully following Hungarian case as well, we all know that the EU had very harsh response to the Hungarian Enabling Act. My question is, what do you think about the EU response, and was there any response from EU to the Polish COVID-19 measures and everything that happened? So what do you think about that and this EU stance on the Polish case?
Okay, so let me answer the first question. The law, we are this primary legislation that gave the right to the Prime Minister and the Minister of Health to issue secondary legislation. It's an old law. Okay, so it was not enacted under this government. It was enacted, as far as I recall, around 2012 or 2008. So that's an old law. The problem is that, this law is quite general at the level of the primary legislation, because it gives some competences, it gives some rights to the Prime Minister and the Minister of Health. And everything that is crucial for the people's freedoms and constitutional rights happens at the level of the secondary legislation. So, and normally it works, because if you have a general competence at the level of the primary legislation and the details are regulated at the level of the secondary legislation, and the government is exceeding its powers or is going too far at the level of the secondary legislation, you can go to the Constitutional Court and to challenge the secondary legislation as not compliant with the primary legislation. As I said, it was always possible in Poland, so nobody was afraid of a situation like that. Of course, we did not have a situation like that. We had a natural catastrophe, I think a kind of flood in 2011, I think. But it no constitution, but it you cannot compare it to what's going on here. So what I'm saying is that you have an old law that gives a lot of competences to the Prime Minister and the Minister of Health, with the assumption that they are controlled by the Constitutional Court, yeah, that they will not go too far with exercising their powers. But if the Constitutional Court is paralyzed, they can do everything. Yeah? They can go even farther than the constitutional state of emergency is concerned. So one example is the ban on public assemblies. You cannot do this under the constitutional state of natural catastrophe. And they did it on the basis of the statutory state of a pandemic. So here you have a situation in which the secondary legislation goes farther than the constitution in limiting the rights of the people. Yeah. So this is the situation. So this law was, first of all, never used, and the expectation concerning using this law in a regular situation would be that the Prime Minister, the executive branch, the Prime Minister and the Minister of Health, will use the powers in accordance with the primary legislation and in accordance with the Constitution. They failed to do so, but you cannot do anything with the situation like that because you don't have a working constitutional court. Yeah? The second question, as far as I remember, that was quite clearly communicated by the politicians of the Law and Justice Party that they want to have the election quite quickly. Of course, they produce some kind of the legalistic smokescreen that's the constitutional duty to have the election, that endangers the stability of the legal of the state. As I told you, the Polish constitution has been prepared for the situation like that. 20 years ago, we introduced the constitution, this regulation stating that if there is a natural catastrophe, you announce the state of the natural catastrophe and you extend the term of office of the president or parliament if it is necessary, and you work to combat the pandemic. So it was a clear legalistic way out of the situation. They decided not to use it. I think, and you can see it even now if you look into the polls before the 10th of May, the rate of support for President Duda was at the level of 60%. So I think he would have won in the first round of the election because that was more than 50%. Now he's below 40%. Yeah, below 40%. So of course, perhaps there are some other factors that influence that, but the scenario that the longer we have the pandemic, the more difficult will be for the governing party and their president to win the election is true, because there is a difference between 60% and 40% of support rate. And your third question. Even if the regulation introduced by the Polish government was harsh, I think it did not go so far as the enabling act in Hungary, and probably because of the comparison, because this tragic situation, I think, in Hungary, and this acceptable situation in Poland. I think the European Union was not so interested in what's going on in Poland. The other reason is that the Polish government committed, more obvious constitutional crimes in recent years. concerning the Constitutional Court, concerning the National Judiciary Council, concerning the Supreme Court. So a situation in which you use the wrong legal tool, I mean the statutory state of emergency, instead of the constitutional state of emergency, seemed not as such a great sin, yeah, I would say. So I think that would be perhaps, that would be an explanation why the European Union was not so interested, I think, in Poland, or not so interested in Poland as it was in Hungarian situation.
Thank you, Professor. Next question comes from Anna Zdravkovic, a PhD candidate at the University of Belgrade Faculty of Law. Anna, I'm giving you the floor, and could you please put your hand down?
Thank you, Stefan. Thank you so much, Professor, for this very interesting presentation. It was quite thought-provoking to hear about the situation in Poland, as it is quite opposed as to what we had in Serbia. Basically, we did have a state of emergency, and I personally am not sure that we needed it. However, my question has to do with non-derogable rights, or as we call them, absolute human rights. Since you have mentioned that, for instance, freedom of assembly cannot be limited or shouldn't have been limited, I would like to know if there are actually any non-derogable rights according to the Constitution, and were they unlawfully derogated or limited during this statutory state of emergency? Thank you.
I think there are such rights in the Polish Constitution, for example, human dignity, of course. Unfortunately enough, no attempts have been made to infringe this right. As far as the freedom of assembly is concerned, the problem was that, you know, because of the lockdown, the government went too far and they banned, I mean, every public meetings in which more than 2 people participate. So it covered any public assembly as well. And of course, it was a problem, especially because they wanted to hold the election. It's quite difficult to carry out the presidential campaign if you cannot meet the people. Yeah, and on the other hand, it's difficult to understand why, because of this kind of natural catastrophe, you cannot have people protesting, for example, in a way compliant with some kind of limitations. The Polish government, as I said, introduced a total ban on the public assembly. But as I said, I think the only problem was the connection between the public assemblies and the election, upcoming election. That was a problem. The Polish courts, not the Constitutional Court, but the regular courts, in particular the Polish Administrative Court, stated already that this ban on public, this 100% ban or complete ban on public assemblies is unconstitutional. So when the regular courts in Poland state something like that, it doesn't have an effect on the law itself. So the law is in force still, but the law is not applied in the particular case. But it shows, as I said, that the Polish government simply went too far in some decisions.
Thank you, Professor, for your answer. Our next question comes from Dr. Nina Kryszlinin, an associate professor in legal history at the University of Belgrade Faculty of Law. Professor, you have the floor.
Thank you very much. Thank you, Professor Matczak, for your interesting lecture. I'm sorry that I haven't been really following the situation in Poland through the media, but I presume that this sort of behavior of the government has provoked at least some sort of negative response in the media. So I'm curious whether they have tried to justify in any legally or at least legitimately acceptable way their intention to hold the elections and not introduce the state of emergency in such a situation.
First of all, the Polish government communicated to the public that it has the situation under control, and they indicated that the Polish constitution says that one introduces the state of emergency, the state of the natural catastrophe, when other constitutional means are not sufficient. So they believe, and they try to convince the general public, that the regular tools are sufficient. As I said, it is not true, because the regular tools went much too far. They were farther than the constitutional tools, so they were unconstitutional. So by definition, you cannot say that unconstitutional tools are normal constitutional tools according to the Constitution. Second, if you look into the laws they produced, especially the election laws concerning the presidential election, they all introduce quite special particular regulations concerning the election. As I said, a universal postal ballot, which is not a normal situation. And even in the title of these laws, in the titles of these laws, you have the words like a special regulation or extraordinary regulation, which shows quite clearly that this argumentation that they have the situation under control and no special constitutional tools are necessary is simply not true. Second, they use, I think it's the feature of the autocratic governments that when they remove all the constitutional checks and balances, they like very much to evoke the Constitution. So if they have the Constitution under their full control, they evoke the Constitution. So the Polish government tried to convince the general public that, as I said, it is our constitutional duty to have the election on the 10th May, and that's something very bad will happen if this is not if it is not the case. As I said, again, that's not true, because there is a special system in a systemic tool in the Constitution, the state of natural catastrophe. But the Polish Constitution stipulates that if you don't have a president, there is a clear mechanism of substituting for him by the Marshal of the Sejm, and so on and so on. And we already, unfortunately, exercised this mechanism in 2010 after our President Kaczyński died in Smolensk. Yeah, so that's a mechanism that secures the continuity of the power. So again, these arguments were not convincing. So to answer your question, yes, the government tried to convince everybody that, first of all, they don't have the constitutional duty to announce the state of emergency. Second, that they have a constitutional duty to hold the election. Neither of the statements is true, I believe, and both statements were criticized by the lawyers, by the constitutional lawyers, in the opinions we prepared for the Polish Senate, and by the Polish ombudsman Adam Bodnar, and I believe that it is now clear for the Polish citizens that this argumentation presented by the government simply was not proper.
Thank you very much, Professor. If no one else has a question, I do have one. If anyone has a question, I would like to ask them to raise your hand. All right. So I will allow myself to ask my own question. So my question doesn't concern really state of emergency in Poland. It rather concerns the court situation that's going on there. Some years ago, when I was still on undergraduate studies at the University of Belgrade, I wrote a paper about the Polish constitutional crisis, and I would like to ask you to comment on, well, given the fact that between Polish presidential candidates, Mr. Duda and Mr. Trzaskowski, if I'm pronouncing it correctly.
Yeah, it's a very difficult name to pronounce. Okay.
Very well. So according to my information, the latest information I have, that's from the end of May, President Duda's approval rating hangs on at about 35%. So let's say let's suppose that the civil coalition wins the election. So Mr. Trzaskowski wins the election. Do you think that the deficiencies in the appointment of judges of the Constitutional Court would be swiftly reversed? And if so, in what way? If I recall correctly, the problem in 2015 was the appointment of judges. So they passed the process at the same, but they weren't sworn in by the president. So that was the essential problem. Do you think in that way, if there is a civil coalition win at the presidential elections, I think that might call for snap elections in Poland, snap parliamentary elections. I would like to ask you, well, just to comment on that situation, do you think that, all the systemic deficiencies would be reversed by this eventual new Sejm?
Oh, that's quite a complex question. First of all, okay, let me start like that. I work for foundation, Battery Foundation, which is the biggest Polish NGOs. And in January 2019, before the Polish elections, parliamentary elections, we carry out a huge study about how to bring the rule of law back in Poland. Yeah, and we divided ourselves into several teams, working on each institution that was commandeered by the Law and Justice. So the Constitutional Tribunal, the National Judiciary Council, the Supreme Court, and so on and so on. So we tried to prepare some kind of scenario how to, bring back the rule of law, how to fix it when the democratic parties will win elections. That was not the case, but you are right that it may change. Yeah. So what I will refer to our study in a moment, but what we are facing now is a situation in which there is a chance for Mr. Trzaskowski to win the election. Yeah, there is. I think it is going to be close shave, yeah, for sure, and there is a chance. As you know, the Polish system is quite complex. Constitutional system. Even if we have a president elected in the universal election, the powers of the president are quite limited. But he can veto the statutes enacted by the parliament, and it's quite difficult to overcome this veto. So we can expect that we may have two situations. First of all, if Trzaskowski wins the election, the Law and Justice Party may try to work with him, which will be difficult, I think. And after some time, and these are the predictions the Polish politicians have, after some time, we may have an early election, parliamentary election in Poland. If the democratic forces win these parliamentary elections, the possibility to fix the rule of law will be available for sure, because if you have a president and the parliament, you can do a lot. Nevertheless, there will be a question how to do this, because I think there are two scenarios. First of all, you can mirror what the Law and Justice did. So, because they remove the judges from the Supreme Court, so perhaps the Democratic Party that wins the election should also remove all the judges from the Supreme Court. Yeah, that's one option. The second option is that perhaps you should not follow their actions, which were highly unconstitutional, but to act in a way that is respectful to the law. But if you do, you will not be effective, because if you don't remove the judges, of course, they will block any action. So, for example, any laws enacted by the new parliament can be sent by the opposition, by the Law and Justice Party, then in the opposition to the Constitutional Court, and found unconstitutional. So, in our study in the Battery Foundation, we nevertheless recommended that the new government and the new parliament should follow a legalistic path. So even if it is going to take longer, we cannot repeat what the Law and Justice did, because that would be like setting the precedent. Yeah, I think every new government, every new parliament in Poland after that would have, I think, a right to change all the judges in the country. So we recommended to take the legalistic path. I know that perhaps it is not very pragmatic, but we believe that's the right way. I think you are specifically asking about the situation in the Constitutional Tribunal, because you are right that in 2015, the previous parliament, this pre-Law and Justice Party parliament, appointed legally 3 judges that should have entered the Constitutional Court, but the president refused to take the oath from them, and finally they were not they were not enter they did not enter the court. So probably you are thinking that the new president could appoint the judges, the 3 judges, to the Constitutional Tribunal. It's not so easy because, of course, the places of the 3 judges were already taken. So we have 15 judges, and that's the constitutional limit. So before President Trzaskowski, if he is a president, appoints the old 3 judges, he will have to remove the incumbent judges. And you have the same question: has he the right to do so or not? With regard to the Constitutional Court judges, we found in our study a legalistic solution for the president and the parliament together to remove 3 illegally appointed judges and to appoint the 3 old ones. But that's only a part of the problem. That's only a part of the problem in one of the institutions, namely the Constitutional Tribunal, and we have a problem in 3 institutions, in the Constitutional Tribunal, the National Judiciary Council, and the Supreme Court. And there are no good responses and no good scenarios for the National Judiciary Council and the Supreme Court, because they are both protected constitutionally, and there is no regulation in our constitution that says that if you fix the rule of law, you can infringe the constitution. So by no means it is going to be an easy task to restore the rule of law in Poland.
Well, thank you for your exhaustive response to my question. You actually went very in detail with regard to my question. I really appreciate your response. Anyway, we are now at the end of our allotted time. I would like to thank all of the participants for attending this webinar, and I would like to thank you as well, Professor Matczak, for your amazing presentation and for taking the time to speak for us.
My pleasure. Thank you very much. Thank you for inviting me to give this speech, and thank you for attending and for your questions. I hope there will be another opportunity to meet and discuss these issues.
That would be a great pleasure for us all. I wish all of you a great evening, and take care of yourselves.
Thank you very much.
Goodbye.
Bye-bye.